Yes, sir. Mm-hmm.
May I reserve 2 minutes for rebuttal?
You may. Mm-hmm.
May it please the court, my name is Louis Patino. I represent Jessie Connatser.
Mm-hmm.
9 years ago, these parties commenced an action in the Fourth Circuit Court for a parentage plan. A parenting plan was entered as part of that cause. The children were also decided to reside primarily with the mother, my client, in Hanover County, Virginia. Since then, the children remained in Hanover schools. The father has remained in Tennessee, and custody litigation has continued over the years, which has brought us here today. Our first issue is whether the trial court erred, ruling that it had exclusive continuous jurisdiction over the parties in Knoxville. Tennessee is no longer the home state, so the UCC JEA triggered opportunity for my client to file for domestication in Virginia. This was accepted in Virginia, but this was not approved in the Fourth Circuit Court. The mother has had to travel 7 hours each way to court here in Knoxville for years. The minor children have to attend school now, and they're unavailable for court.
As far as the traveling goes, I mean, if we were to say that Virginia had jurisdiction, then the opposite would be true.
Yes, Your Honor. I was getting into the best interest of the child. I don't believe that it's in the best interest of the children for the mother to be gone all this time for all this litigation. I was also getting into the fact that the children are actually present in Hanover as well. That's just a more convenient for them, and it's in the best interest of the children. I understand that the inconvenience alone isn't a matter for removal. Opposing counsel states in his brief that my client took time to look for an attorney, which is true. He also states that she didn't come back with one. Well, that's also true. She was unable to afford an attorney, and I don't believe that that should be held against her. This litigation has become so burdensome that she couldn't afford counsel. And she did properly move to Virginia as well. I wanted to make that point. The court allowed for her to move to Virginia as part of the first order. One of the cases that we cited in our brief, Graham versus Graham, addresses the court's discretion where a party moves out of state. This 2009 ruling stated that jurisdiction was in Florida, although father lived in Tennessee and had parenting time with the minor children. To be clear, this case started in Tennessee, was adjudicated in Tennessee where the court allowed for the mother to move out of state. Then upon further filings, the appellate court released jurisdiction to the new home state. The facts of Graham are just like our facts. The Graham case relies on Lee versus Lee. In Lee, the mother lived out of state for 8 years, and the minor children had visitation through a parenting plan. The father continued to reside in Tennessee. The court ruled that jurisdiction was in the new home state. The facts in Lee are also just like our facts. This case was also adjudicated in Tennessee, where the court allowed for the mother to move away with the minor children. And during this further litigation, we are asking that the court should have released the case to the new home state. The permanent parenting plan, which is adjudicated in Tennessee, was also fully dependent on the Hanover schools, the school district where the children currently reside. In fact, one can say it revolves around the Hanover school calendar. Every person that could speak to these children in a professional capacity, such as teachers, physicians, counselors, or anybody else, would reside in Virginia.
I don't see, at least in this particular record, that there are any issues that would require all of that. I mean, yes, it's true that that's where the kids live and that's where they go to school, but like what we're here for today is basically the contempt finding and the attorney's fees.
The first issue that we addressed actually was the jurisdictional argument.
Right.
Yeah. So my client would have liked that opportunity to be able to call witnesses. She wasn't able to call witnesses. They were unavailable to appear here from Virginia.
Okay.
As ordered in the best interest of the children, my client, the mother, was found to be the proper parent, to be the primary residential parent, and found to be at an appropriate home in Virginia for the children. Any such further litigation or modifications should be made in Virginia is our position. As far as previous rulings of the court, one of the reasons that the Fourth Circuit Court held on to this case was because of their familiarity with the case. But after a parenting plan is entered, all of those issues are precluded before the permanent parenting plan that was entered. So we find that inconsistent with law that the judge would hang on to the case just because of familiarity when a new case is open with a time cutoff at the previous parenting plan. That just doesn't make any sense to us either. The second issue that we were going to discuss was whether the school schedule change was a material change in circumstances. Since that parenting plan revolved around the school schedule, we believe that the school change was a material change in circumstances. Furthermore, the children's ages changed such that they were now involved in extracurricular activities that weren't at issue before. Again, the case history reveals that the entire plan was designed around the school schedule. And opposing counsel submitted testimony trying to prove that the change was immaterial. However, our client did introduce Exhibit 1 and Exhibit 3 for the 23-24 school year, as well as the 24-25 school year, trying to show these differences. And one of the contempt issues is related to this as well. And the school calendar did change after the entry of the most recent permanent parenting plan. Considering this an immaterial change, we believe is inconsistent with previous law. Education is always held important for the children, and one of the issues that we wanted to have addressed was that an inability for the children to study for final exams should have been something that was considered to avoid issues with the parenting plan, make it something that the parties could follow and something that was beneficial for the children. Accordingly, it's our position that the court erred when they said that the academic calendar change was not a material change in circumstances, and we're asking for that decision to be reversed and remanded. The third issue are the issues of the contempt rulings. The first alleged violation in contempt was an October issue where the father used to have Columbus Day weekend, and Columbus Day had been removed from the school calendar. Since Columbus Day was removed, it reverts back to another writing in the parenting plan stating that where father doesn't have a 3-day weekend in a month, he should get a weekend in Virginia. The father requested the weekend of the 18th. The mother declined just that weekend. She told him that other weekends would be available with her schedule. He chose not to take one of those weekends. It's our position that our client actually followed the parenting plan in accommodating the father, and that she was not in contempt there. As far as the second allegation of contempt, we feel that our client also did not violate there. She took a vacation to Alaska, which father admits he received notice of in his brief, but she was entitled to 1 week as long as she didn't interfere with certain days and holidays, such as Father's birthday, the 4th of July, and Father's Day. None of that was interfered with, so mother just exercised her week for the summer as per the parenting plan. So our position there is that there was no contempt, and that decision should be reversed and remanded as well. The final issue is whether the award of fees from the trial court was proper. Our position is that it was not. In our brief, we included a 10-factor test that's the law for deciding whether fees are reasonable. The case history does not show that there was any analysis based on the reasonableness of fees. We don't believe that there should be a ruling just to punish one individual, or a punitive ruling for attorney's fees. And any argument that was made making these punitive should be disregarded, such as mother's behavior through the case. Nothing in the court record suggests that these fees are reasonable. Nothing in the court record suggests that the fees were even reviewed for reasonableness, and accordingly, our position is for the award of fees, as well as the entire fee amount, be reversed and remanded for further ruling by the Fourth Circuit Court. That's all we have. Thank you.
Thank you. Yes, sir.
Please, the court. I'm Brent Watson. I represent Mr. Penner in this case, represented Mr. Penner at the trial. Let me start with the attorney's fee issue first, since it was just mentioned. An affidavit of attorney's fees, very detailed affidavit, was submitted showing what time was spent on different issues, and that was submitted to the court. It was also submitted to the mother. The mother did not ask the court to review that, did not take any action to have a further hearing on that issue. under the authority of Kennedy versus Kennedy, it is incumbent upon the party challenging the fee to pursue the correction of the error at the trial court by insisting upon a hearing on that issue. Since there was never a chance for the trial court to rule on whether the attorney's fees were reasonable and whether they were proper and appropriate in this case, trial court was never given an opportunity to do that, which I think is required before she comes to the Court of Appeals on that issue. I will say this, that all of the causes of action that the father pursued at the hearing, mainly contempt and modification, are certainly issues under 36-5103 where attorney's fees can be awarded by the court, and it's in the discretion of the court. In this case, we submitted an affidavit of attorney's fees getting through this process of over $40,000, and he awarded $15,000 of that, which would indicate to the court, to me, that the court went through and did make some analysis as to the reasonableness of those fees and allocate them to certain issues that they were properly allocated to. One of the things that the court mentioned several times was that the mother prolonged this process. She filed a number of motions. She's filed this same motion with regard to jurisdiction for many years. It's been denied. It was denied the year prior to our trial when she was represented by counsel. And she told the court that she needed a continuance in order to get an attorney. Then she didn't hire an attorney. She was ordered to appear for deposition. She did not appear at deposition, which required another continuance of the trial date. And I think that the court, actually the court does say that part of the reason for the attorney's fees and the amount of the attorney's fees is the fact that she prolonged this process so long. She was found guilty of civil contempt. The court did, in fact, modify the parenting plan, which opens the door for attorney's fees on the issues of modification of that parenting plan. One of the things that the court said was that the mother made a very simple case complicated and took longer and took more time than it should have. He also found that the mother did not act in the best interests of the children, but actually acted in her interest rather than the children. And he made that statement several times in the final judgment of this case. Going back to the issue of jurisdiction, under 36-6217, we look and we see, does any parent still belong or still live in Tennessee? In this case, obviously, Mr. Pinner's been here. I believe in the course of this trial, the judge mentioned to the mother at some point, did you not realize when I allowed you to move in 2016 that there were going to be issues with regard to parenting and that you may be required to come back to Tennessee at some point? And actually the judge said, I allowed you to move because you promised me you had a wonderful job, and then you never got that job, and you've been in Virginia ever since then. So we have the father still in Tennessee, and then the other issue is there substantial, the substantial evidence is no longer available in Tennessee. And the judge made a finding on that and said there was no issue raised in this case that I needed to go to Virginia. And I think he mentions teachers, doctors, and those people. There was no issue raised that the parties couldn't present the evidence. The mother never asked for the court to provide some means to acquire evidence or testimony from witnesses out of the state. She could have asked or filed a motion, I guess, to have them testify by Zoom or other means. She never put me on notice to go to Virginia to take a deposition because there was an unavailable witness. Quite honestly, I believe the record would be void of any mention of her that she wanted to call additional witnesses and was not allowed because of the fact that the case is being handled in Tennessee. This was simply a case of, I'll call it tweaking for better reason, tweaking the parenting plan to try to better accommodate the fact that they're trying to parent these children from two different states. The Graham case and the Lee case were both cases where the mothers in both cases had been allowed to move, I believe, to Florida and California. But then it became a time to change primary residence. And so the father is asked to basically change custody in our old terms, and give them primary responsibility for the children. And most of the complaints that the plaintiff fathers had involved the children's situations in the foreign state. I believe in the Lee case, it was a stepfather or something that was acting up in Florida. I understand that. There was no issues or testimony in this case that anything was going on in Virginia that affected the parenting. It was simply a matter of trying to fix these little problems that existed in these people trying to parent together. As far as the inconvenient forum argument, statute clearly is the court may decline to exercise jurisdiction. Is not mandatory. There's no question the kids have been gone for since 2016. I mentioned this, the court's already mentioned that the distance travel was going to be equal for either parent. Either one was going to be disadvantaged. And the mother knew that when she decided she wanted to go to Virginia. Financial circumstances, which was raised by counsel, as is stated in our brief, any mention that she had about the financial circumstances were made in her opening argument she never presented proof from the witness stand under oath with regard to financial circumstances. And so that cannot be considered. And then the nature and location of evidence, as I just said, there was no evidence that wasn't available here in Tennessee. Ability of each court to decide expeditiously. These petitions and motions had been filed and pending in Knoxville for years, actually. The court in Tennessee had set this matter for trial on several occasions, and they were always continued because of the mother. She wanted to get a lawyer. She wouldn't appear for depositions. Court here was ready, willing, and able to try this case. There are no pleadings pending in Virginia that I'm aware of, even though she did go and try to domesticate the order. She never filed any motions or petitions, so any relief that she would seek would have been months or years down the road after she filed in Virginia. So Tennessee certainly could have provided a remedy to these parties much more quickly than Virginia. And the last one is familiarity of the court with the facts and issues. Judge McMillan's lived with this case. As he said in his memorandum opinion, he's seen these people repeatedly since 2016. He tried a case with them in 2019. There was an order put down in 2020, and there's been several motions filed since that time. So Tennessee is not an inconvenient forum. And most of those factors of 36.6.222 favor the father's situation. One thing that I think is incorrect that the appellant has said here today and also said in the brief was that the court did not find a change of circumstance. The court clearly said, I find a change of circumstance. And the reason they found change of circumstance is because the mother had denied him parenting time under the parenting plan, which is, under the rules, a ground for a change of circumstances. The court went through and considered this issue of Memorial Day. And we cite the testimony and the judge's statement in our brief, but basically the judge goes through an analysis of this Memorial Day and says the daughter had mandatory dance practice, but she didn't have it in Memorial Day, but she would have it in Labor Day. And he said, I think the children can study just as well, being with the father. the mother testified that the children may not even have these finals. So what the judge did is he left the Memorial Day with the father and found that it was in the best interest of the children to stay with the father on Memorial Day, and gave the mother Labor Day, which she had wanted because her birthday is a couple of days, and the daughter has mandatory dance practice and this and that. So he modified, after an analysis of what to do with Memorial Day and what to do with Labor Day, and he made a decision, and he modified the parenting plan based upon that. Last are these contempt issues. The mother, on several occasions, gave testimony where she basically said, well, you'll have to take me to court over that. It was over a passport. And this is all in the record and cited in our brief. In June, she knew that my client was coming to Virginia to pick the children up at 3 o'clock the Saturday following the last day of school. Obviously, that allowed him to get the children home to Tennessee by 10 o'clock, a 7-hour drive. She chose to take her week beginning when school was out. She was put on notice that we expected to pick the kids up at 3 o'clock as the court had intended. And her response was, you can pick the kids up at 11:30 and then you can drive back to Knoxville. Which, if that doesn't show willfulness and contemptuous behavior, I don't know what. And then when she's charged with this, she says, oh, well, I didn't understand. Well, she understood that there was a purpose at 3 o'clock on a Saturday to pick the kids up. She took her week. She decided to go over there and then had the audacity to say to the father, well, you can pick them up at 11:30 and drive back to Tennessee. And he said, I don't want to do that. It's not safe. And in fact, he picked the children up on Monday, and then she refused to give him those days later. I don't know really how a better case could be drawn for someone acting willfully and in violation of the court's order. In this case, whenever the mother was caught or charged with something she didn't understand. In October, the parenting plan clearly says that if the father does not have a designated time during the month, he has a long weekend with the children. The long weekend was the weekend where the kids were out of school on a Friday and they were out of school on a Monday. He gave her notice, wrote her a letter, gave her notice, that's my weekend under the parenting plan, I'm to have the long weekend. She said, well, I'm sorry, I'm taking the son to a football game, I believe in Philadelphia somewhere. They went back and forth, and she was denied that weekend. But in the judge's opinion, when you read it, it doesn't say it's just that weekend. He says the mother has denied the father weekend visitation during other months. And actually, he never actually, the appellant has taken that to be that weekend, but the court made a more general statement that the mother had done this before and had done it in October. Again, the mother says, well, I didn't understand. Well, the parties had co-parented under this parenting schedule for years, and it's only because she wanted to take the son somewhere and the father said, it's my weekend, that all of a sudden she doesn't understand. We have to have a lawful order. We certainly have, clear, specific, unambiguous. The court finds, and I think in the final judgment, there's no question that this is what he intended. This is what the language of the parenting plan says. He shall have a long weekend if there's not a designated time. She certainly disobeyed it, and when it was brought up to her, that's when she says, well, you'll have to take that up in court. And she got what she asked for. It got taken up in court, and unfortunately for her, it's contemptuous. Last thing I will say is we did ask for attorney's fees for frivolous appeal. I sat here and I listened to the other cases being tried before you. These are issues that should be worked out between these parties. The judge said, the problem in this case is failure, I guess, to communicate or make agreements, and that's exactly right. So for these reasons, We'd ask you to deny the appeal.
Thank you. Your rebuttal, sir.
As for the issue of fees, we believe that we have some legitimate issues to discuss here. There's nothing frivolous about our appeal, and we're happy to be heard today. As far as the contempt, again, nothing in the parenting plan says that my client's vacation needed to end at 3 o'clock. Nothing actually stated that it couldn't interfere with father's time as long as it wasn't certain holidays. Those holidays were not impacted. Furthermore, the October issue, nothing states that the father was entitled to the weekend of the 18th. Counsel stated that they weren't just alleging that weekend, and then he reinforced his argument by stating it was the 18th that was impacted, that that was the father's weekend. But Columbus Day was lost. That was not the father's weekend. He was just entitled to a weekend. I wanted to make that clear. There's no violation of the order, so there is no contempt. As far as mother failing to show up for a deposition, she requested to appear by Zoom, and that was denied. As far as having witnesses appear via Zoom, my client did not think that that was an option. Zoom was already declined. My client was a pro se litigant. She defended herself as best as she could. She cares about her kids, and she cares about these issues in the best interest of her kids, not just herself. As far as the fees that were awarded as part of the trial, there was no ruling on how much of that was for contempt, how much of it was for the case in general. And that affidavit was submitted but wasn't referenced. Again, the trial court did not go over any of those factors. They simply just stated in a ruling as far as what they thought was fair. They didn't address any of those other factors. Thank you.
Thank you. Let me thank both parties for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. There's nothing further.